Jen, good morning and welcome to SIROHI'S Law classes series on discussions on landmark judgments of the Supreme Court. Today we have a very interesting topic and of investigation. An investigation and what are the powers of the magistrate over the investigation when after registration of the case police is not performing its duty in right perspective, resulting into no proper investigation. The very purpose of the CRPC and any criminal justice dispensation system is to have a fair and proper investigation. What are the remedies if the police is not discharging his duties in right perspective? What the rights are available with the complainant? What the complainant should do? Most of the times you see that the people approach the Honorable High Courts under Section 482 for a direction to the police to do the proper investigation. But there is a case of Honorable Supreme Court decided on this point which most of us may not be aware of. The decision was Sakri Basu versus State of UP, and in 2007 it was decided by Honorable Justice A.K. Mathur and Honorable Justice Markande Kadju in Supreme Court. The matter was like this, which I have already told you. The police was not discharging its duties and no proper investigation was being carried out. So the complainant reached the High Court. High Court refused to intervene, then Supreme Court, then this Honorable Supreme Court got opportunity to comment on this subject matter. Honorable Supreme Court, referring the provision of Section 156 Clause 3 CRPC, which provides that if the police does not register a FIR on being informed regarding a cognizable case, the Chief Judicial Magistrate or the magistrate concerned has power to direct the police to register the FIR and to have the proper investigation of the FIR. So, interpreting this provision of Section 156 Clause 3 CRPC, Honorable Supreme Court held that when the magistrate has power to register the FIR, it includes the power to have proper investigation. It has power to see whether the registered FIR is being properly investigated. Though this power is not explicitly is there in the provision, but it is inbuilt. Honorable Supreme Court said that where FIR is not lodged, magistrate can order registration of the FIR. When the police is not investigating the matter, the magistrate can give direction to the police for proper investigation of the case. But remember to note that there is a demarcation line. Giving direction for proper investigation and it is to be distinguished from interfering with the investigation, because interference in the investigation is not permissible at all, even by the magistrate. Magistrate can never interfere with the investigation. What powers the investigating officer has, what opinion investigation officer has formed, the magistrate cannot intervene in it. Cannot intervene, cannot interfere. But if the magistrate, if the investigating officer is not doing the proper investigation, how? You can see if he is not recording the statements of the eyewitnesses, if he is not collecting the evidence, he is not sending the collected evidence to the forensic science laboratory, he is not doing anything and just keeping the investigation pending, no progress is being made. In all these scenarios, the magistrate is not handicapped, and he can certainly intervene. As you know that after the police report under section 173 clause 2 CRPC, in the form of final report or in the form of the charge sheet, at the time of taking cognizance, magistrate has ample power to give assent or act in accordance with the findings recorded by the IO, or may have a different view. He is not buying the report of the police submitted under section 173 clause 2. He can make a different opinion and may proceed against persons who have not been named in the FIR, and also he can add and subtract the sections which in the opinion of the magistrate the offense might have been made out. This is the power of the magistrate. Recently, Honorable Supreme Court in M. Subramaniam and another versus S. Janaki and another in 2020 SCC online page 341. Honorable Supreme Court reiterated or followed this judgment of the Sakri Vasu versus State of UP and held that, in our opinion, section 156 clause 3 CRP is wide enough to include all such powers in a magistrate which are necessary for ensuring proper investigation. And it includes the power to order the registration of the FIR and order a proper investigation if the magistrate is satisfied that a proper investigation has not been done or is not being done by the police. Section 156 clause 3 CRPC, though briefly worded, in our opinion is very wide and will include all such incidental powers as are necessary for ensuring a proper investigation. So, the myth among us in legal fraternity that the magistrate cannot ask the IO, cannot direct the police is not good. We must understand this law. We must know the power of the magistrate during the investigation over the investigating officer, and always must distinguish the interference in the investigation with the order securing a proper investigation. And no doubt the magistrate has power to ensure the proper investigation. In 2016 also, in Sudhir Bhaskara Rao Tambe versus Hemant Yashwant Dange 6 SCC 277, the Supreme Court followed the Sakri Vasu case and reiterated its earlier view. So, the 2-3 cases which I have cited here, net result is that the magistrate must be approached by the complainant if police is not discharging its duties in right perspective for ensuring the proper investigation of the case. Ensuring proper investigation of the case is not only the duty of the investigating officer police, but also the duty of the magistrate concerned, having jurisdiction over that police station. So if the police is failing in its discharge of official duties, then the magistrate must be approached, not the High Court under section 482. We must check this practice of approaching the Honorable High Court under section 482 because it overburdens the High Courts and judicial system. And in legal fraternity, we must keep a check on this issue, and the problem which can be sorted out with the magistrate very easily should not be referred to the High Court. It will help the litigants and the judicial system as well. Thank you.